We are live with another episode of Level Up Law. We're here at South Carolina Legal Services. We are leveling up your legal knowledge on the different areas of law that we practice in. Welcome, everyone, and thank you for joining us today. I'm Susan Ingalls, Senior Staff Attorney and Consumer Law Unit Head here at Legal Services. And helping us out in the background is our producer, Kenneth Elliott, from our IT department. Always glad that he is here. Today, we'll be talking about the Doctrine of Necessaries. Most people haven't even heard about the Doctrine of Necessaries, so hopefully it'll be informative presentation for you, though short, thankfully. I do want to remind everyone that this webcast is being recorded, and we will post it to our YouTube channel later on after we're finished, and you'll be able to find it there. We'll also link to previous Level Up Law episodes that may be helpful on this same subject matter. I do want to remind you, as always, that this is not legal advice. We're not your lawyers, although we are lawyers, but you would want to check with your own lawyer to get legal advice on any subject matter that you're needing assistance on. So this is just general information for the public. At the end of the presentation, though, we will provide information about how to apply for our assistance if you have an issue, and we always encourage you to do that. If you have any questions during the presentation, please put them in the question box that should be on your screen, and I will be glad to try to answer those. You will be in listen-only mode today, so definitely ask any questions through the question box. So let's get started. The Doctrine of Necessaries, what is it and what does it mean for you? Sometimes it's called the Doctrine of Necessities. But it typically means that a husband or wife or spouse in a civil union or something like that, that they are responsible for the necessary expenses of the other spouse during their lives and sometimes after their death. Usually, in this day and age, the word or the term necessary is really referring to medical bills. That's the context in which we usually see the Doctrine of Necessaries come up, so we'll talk about that more in just a little bit. But it can include also shelters such as a nursing home. Okay. So where does this term come from, the Doctrine of Necessaries? You know, back in the old days, the old common law rule was that a husband was responsible for the debts and expenses of his wife. One of my law professors back in the day always said that the common law rule was that the husband and wife are one, and that one is the husband. That's obviously not true anymore, and so this particular doctrine has changed over time, but it still has relevance in South Carolina, as I said, typically in the medical bill situation. So, you know, back in the day, women weren't allowed to own property. They couldn't incur a debt of their own. And so that was why that common law recognized that the husband had a duty to support the wife, pay for her necessary expenses, and so forth. So even then, that included, of course, medical treatment, medical care, and that sort of thing. So the important thing to know, which was true in the common law and is true today, that the Doctrine of Necessaries is not a right that is between the spouses. Although there may be that obligation, marital support, certainly in most situations there is, but the Doctrine of Necessaries applies to basically that creditor. And in the typical situation, again, it's going to be for medical bills. So the creditor can sue a husband and wife for the necessary expense of just one of them. And it used to be in South Carolina that you would sue the person who had incurred the bill first, and then if they couldn't pay it, you could then sue the spouse. But case law changed that, and now you can go ahead and do the one lawsuit against both of the spouses. And that totally makes sense because it's much more efficient from the standpoint of our court's time. So it's important to note, I think, at this point that in general, as a spouse, you're not responsible for a contract that your spouse signs or some other kind of tort, like let's say, a car wreck. If your spouse is in a car wreck, you wouldn't be liable unless in some, one example where you would be liable in that situation would be if you're the owner of the car and the spouse was just driving the car with your permission. That might be a different situation. But for the most part, a spouse is not responsible for debts or liabilities of their spouse that were only incurred really by that spouse. And that's true for the most part. There are some exceptions. So let's start first with this typical situation where the doctrine of necessaries comes up. And that's typically, and certainly here at Legal Services, what we usually see is a hospital that is suing a husband and wife or two spouses for that one debt of only one of the people. So that's, again, a typical situation. So that's kind of what I'll be talking about today. It's usually the only place that we see this doctrine come up. So let's say one spouse has incurred a large hospital bill. The hospital then, under current law, would typically sue both spouses, for example, husband and wife, and try to get a judgment. And, if in fact they can prove that that money is owed and that that treatment was provided, then they're probably going to get that judgment. Now, the judgment becomes a lien on any real estate that is owned by the two spouses. Usually that's going to, in most cases, be their residence or their home. And that lien is going to be good for 10 years. Now, in South Carolina, the lien is not renewable. In some cases, for example, North Carolina, that judgment can be renewed over and over again. Here, it's good for 10 years, and if they don't collect it during that 10-year period, then they have no way to enforce it after the 10 years expires. Now, having a lien on your home by way of a judgment, which is called a judgment lien. We think about having a mortgage on our house, that's a mortgage lien. When someone gets a judgment against you, they have a judgment lien against any real estate that you own. So if a hospital gets a judgment against you for a bill that you owe, then the fact that they will then have that judgment lien on your home means that they can later on, not in that same lawsuit, but later on, ask the court to sell your home to pay that judgment. So that's a big concern, and this is where the doctrine of necessaries becomes really important, because you want to protect your home from that happening. Now, property is sometimes exempt from being sold to pay that hospital judgment, and the reference there for the South Carolina exemptions is Code Section 15-41-30. They list all the types of property that you have that are exempt from being sold to pay your debts. And it's basically values. For example, in the home situation, you have a exemption of $60,975 in South Carolina. We have those certain exemptions in our code. So let's look at a couple of examples of how that might work and whether or not your home would be protected in a certain situation. So we're going to say that for this example, the hospital has sued you and got a judgment against you and your spouse for $20,000. Okay, and you and your spouse own your home. I'm sorry, in this particular situation, there's only one spouse who owns the home and there's no mortgage on the home. Sometimes a spouse will put the home only in the name of the other spouse, and they think that maybe that's going to protect the home. What it does, in fact, in the exemption and later on bankruptcy potentially situation, is that you lose that additional exemption amount because each spouse has their own exemption amount of $60,975 in real property that they own. So if the home is only titled in one spouse's name, then the total amount of your exemption is $60,975, whereas if it was in both spouses' names, it would be $121,950, I think. So it's important to think about these things, particularly when you own your home, and especially when you don't have a mortgage on your home. You really have to think and plan when you are in this kind of situation. So we have here that the legal exemption amount is $62,000. It's actually $60,975. So that's the amount. If your home is worth $100,000 and you take off your exemption amount, there's no mortgage there, right? You take off your exemption amount, then the equity or the value that's left in your home after subtracting that exemption amount is $39,025. So that's the amount that is subject to paying that judgment. But as you can see, you've already used that exemption amount, and so this is actually money that would have, or value that would have to go towards paying that judgment. So in theory, the creditor can then take you to court and ask the court to sell your house because you have that $39,000 or so of equity in it, and then pay that balance to the creditor or the hospital, whoever has the judgment against you, after your exemption amount is subtracted out. So you would have your $60,975 value of your own, but you would really owe the creditor hospital that $39,025. So we'll talk about some ways to handle that, because the situation is not always that your home is going to be sold automatically. There are ways to settle that debt. All right, let's look at example number 2. So your home is worth $100,000, but it's owned by both spouses and it has no mortgage. So the legal exemption amount in South Carolina is $60,975 per spouse. So when both spouses own the home and the deed or title has both names on it, then you can use both exemptions, one for each spouse, and that totals $121,950. So when you subtract that from the value of the home of $100,000, then your home value is going to be greater than the exemption amount. And what that means is the court can't sell your home to pay the debt, because after the exemption amount, there's no equity left in your home. Now, both of those situations deal with a home that does not have a mortgage on it. But really, most of us have a mortgage on our home. And so that mortgage amount also gets subtracted along with the amount of the exemption. So quite often we find that you really don't have equity sufficient in the home for it to be sold to pay one of these judgments, because you take the $100,000, you take off the mortgage amount, and then you take off the exemption amount, and there's no equity after those things that would have to be paid when the house is sold. So you know, it'd be nice to have a house with no mortgage on it, but sometimes that mortgage can be helpful. Let's talk about bankruptcy just a little bit when it comes to the doctrine of necessaries. Now, again, we have these exemptions in South Carolina that I mentioned, and those are also what's available when you file bankruptcy as far as exemptions. There are some exceptions to that depending on if you've only recently moved here or, you know, move from here to another state and some exceptions like that. But for the most part, you're going to be able to use the South Carolina exemptions. So in your home, you would have, as an individual owner, that's $60,975. So here's a couple of ways that that can, that doctrine can apply when it comes to filing bankruptcy. So if you have only one spouse that's filing the bankruptcy, then you may find that the other spouse is also personally responsible for that same debt under the doctrine of necessaries. And so although, for example, the husband may have discharged his own medical debt by filing bankruptcy as an individual, if the wife did not file jointly with him, then she is going to be subject to collection of that debt because it was not discharged in the bankruptcy as to her unless she was one of the ones filing bankruptcy as well as her husband. So you have to think about that when filing bankruptcy. Just because it's discharged as to one spouse, it's not going to be discharged to the other spouse, unless it was a joint filing. Now, the other situation is one that I've already mentioned a little bit, and that is when your home value is more than the exemption amount. And so if you are filing bankruptcy and you have that exemption, but your home value is more, for example, in the example number 2, where the value of the home was $100,000, but both spouses were title holders, so the exemption amount was $121,950. There, you would not have to be concerned. But in example 1, you would have to be concerned because you've got over $39,000 of value that is subject to that hospital debt. So potentially, there is $39,000 there that has to be accounted for somehow and is not subject to an exemption. So there are some considerations that would help you in a bankruptcy there. One is just to consider settlement or some sort of payment plan for that amount that you would be having to somehow pay out in a bankruptcy, and then, you know, just really not file bankruptcy on the judgment debt. That's one option. Another option in bankruptcy is the type of plan, bankruptcy that is a Chapter 13 plan, where you can take an amount of money that's not covered by the exemption and pay that out towards that creditor. And, you know, one final thought on bankruptcy is that sometimes a judgment lien can be avoided, but those are circumstances that are going to be special to each case. Each case has its own facts. So that's something that you would want to talk to a bankruptcy lawyer about. And of course, here at South Carolina Legal Services, we do actually represent folks in bankruptcy. So that is definitely something that we could review with you and see, you know, the best way to handle it. Just a quick mention of probate when it comes to the doctrine of necessaries, and that is that when your spouse dies, it is the estate that is responsible for those medical bills of the deceased. So if there was some insurance that was liable to pay for this medical bill, then obviously that insurance coverage is going to still be available to the estate. Any remaining balance after the insurance pays is going to, however, be a debt of that person's estate. One more note about insurance coverage. There are some circumstances where if one spouse dies and there is some sort of insurance that's available to pay something. There's so many different kinds of insurances. Not time to go into all the different examples in this particular presentation, but in some cases, the spouse who survives can assume the position of that deceased spouse who wasn't insured under the policy that existed before their husband and wife died. So that is one way that insurance coverage can come into play as well. Prenuptial agreements. Now there's something to think about. You know, you might think that prenuptial agreements can avoid this doctrine, but they really usually don't, because medical providers are third parties, and they are not a party to your prenuptial contract or your prenuptial agreement. So you can't really contract them out of getting paid under this law. Sometimes we'll talk about one or two ways of avoiding this, but the prenup isn't going to always do you a lot of good in that situation, because it can't overcome a statutory responsibility or even a common law responsibility sometimes. So the only exception to that we have here, and that is if the spouses were separated when the medical services were provided, and that hospital or other medical provider had actual notice of the separation when they were providing those services. That may be a point at which you would not be responsible if you were separated and they knew about it. Okay, so here's just a few ways to avoid the application of the Doctrine of Necessaries to your situation. First of all, obviously, make sure that both of you have health insurance. You do the best you can to get really good health insurance coverage so you can avoid this kind of situation. I've had a case before where one of the spouses was really in between insurance coverage and had no insurance coverage, and so there was no insurance to pay a really large hospital bill of, I don't know, let's say $50,000. That's a lot. If you don't have health insurance, you know, most of us can't write a check for $50,000, right? And unfortunately, in that situation, only one spouse name was on the home, the title to the home, and it had no mortgage on it. So it was their home was very susceptible to a judgment for that amount of money, for that $50,000, and were unfortunately potentially at risk for a court ordering their home to be sold to pay that $50,000, because even with the exempt amount, there was plenty of value in their house. Luckily, we were able to work that situation out, so that didn't happen. But that's an example of, you know, what can really happen when both spouses get sued by a hospital. You got to think about these things. And, you know, we just often don't think about that. You just don't know some of these little nuances of the law. Now, one thing that I did want to mention also, that if you have a lot of property to protect, you might want to consult with an attorney about an irrevocable trust, because then that is not particularly in your name as one of the, you know, as the spouses, and so not subject to this particular doctrine. Now, you know, that's going to be, you know, potentially an unusual situation, because you may have a lot of property to protect, and you certainly want to get with an estate and trust lawyer that handles that kind of planning, but that's sometimes an option. And finally, I just want to say that all of this illustrates the importance of not only having health insurance coverage, but having some life insurance coverage that would cover those unexpected final expenses, or maybe even long-term care insurance to cover a nursing home costs, and if you're getting life insurance, you want to make sure it's going to cover these things. Sometimes I find that clients are paying out a lot of money for life insurance, and maybe they think it's going to cover their funeral and burial when they pass away. But if that's what you're thinking your life insurance is going to cover, you might want to check out what it really costs to have a funeral and burial these days, because quite often those kind of smaller insurance policies that are supposed to cover that are not even close to what it costs these days. Sometimes you might have started that policy 10 years ago, and when the costs were much less if you passed away and needed your family to be able to have that life insurance money to pay for your funeral and burial expenses. But now it could be 2 or 3 times as much as what you thought it was back then, if you even knew. And it's important to look into that yourself. You don't necessarily want to have your insurance agent being the one that tells you how much a funeral usually costs. You should check it out with an actual funeral home. That's one other way of maybe avoiding the application of the Doctrine of Necessities. That's just a little brief overview of what that Doctrine of Necessities is all about, but it's important to know and to think about when you're planning your finances and so forth, planning about if you're going to buy a house, whose name it's going to be in, and all that. There's so many things that go into that aren't just from the Doctrine of Necessaries. Many things that can come into play when you're deciding to buy a home and whose name it should be in and so forth. For example, one of you may have a lot of student loan debt, and that potentially is going to be, your property may be subject to paying those student loan debts if you're not able to pay them otherwise. So that's just one example of the many other things that can come into play. So it's important when you need to plan your financial life as much as you can, and don't just let it happen to you. Be ready for it. And if something happens and you need assistance from a lawyer, here's all of our information for getting in touch with South Carolina Legal Services. We have a wealth of information on our websites, and those are listed here. You can probably find information, whether it be one of these YouTube videos that we do on Level Up Law, whether it be a blog post that we have made about a particular area of law, or many other resources that we have on our website. We have online classrooms about different topics where you can learn how to represent yourself. We've got quite a number of resources for you guys out there, and we always want you to come check it out and see if that can help you. But also, do be sure to apply for our services. If you're eligible, we may be able to help you. There's never any guarantee that we can take a particular case. We're not like the public defender where we automatically have to represent you because we just don't have enough lawyers to represent everybody that really needs our help. So, but that should not keep you from applying for our assistance. And here's how you do it. We have a toll-free number. Our great intake specialists are standing by there in our intake office, which is led by Managing Attorney Tom Trent, who's terrific. They are there Monday through Friday from 9 to 6. And you can call, anytime during those hours and those days and get through to do an on-the-phone application. But we also have online application now, which is great. And if you look at our YouTube channel, on our Level Up Law playlist, you'll find a Level Up Law episode where Managing Attorney Tom Trent gave some really great tips and tricks on what you need to do and how you need to approach that online application to make sure that it goes through in a timely fashion. So definitely check that out if you need our help. Stay connected through all of our resources, our social media. We're always sharing information there about what we do here at Legal Services. So definitely, follow us on Twitter, like us on Facebook, follow us on Instagram. And of course, if you found this helpful or any of our other videos helpful on our YouTube channel, definitely go there and, click that like button, that subscribe button, sign up for alerts so you'll always know when we post a new video. That's important for you to know about, but it's also important for us because the more people that do that, the more the word is getting out about the help that is available or just all this important information about particular legal topics. So definitely share out those videos if you know somebody that it will be helpful to. Well, I want to thank everyone for joining me today. Thanks to Kenneth, the producer back there in the background. We don't always see him, but he's an important part of what we do here. Appreciate everyone joining us, and we thank you for your interest in the Level Up Law programming that we do and the other resources that we have. I do want to remind everybody again that this is a free resource for you. We do these every week, every Tuesday at noon. We post them to our YouTube channel along with the slides that are used. And so you can always find those there on our YouTube channel. If you go to playlists and go to the Level Up, we have a number of playlists about all kind of different topics, but there's a separate playlist for these Level Up Law episodes. And you can go there and scroll through the well over 50 episodes that we have on different legal topics. So thank you again for joining us, and remember to join us next Tuesday at noon for another episode of Level Up Law from South Carolina Legal Services. Thanks for joining us. That's the end of today's episode.